The question is that the motion be agreed to.
Mr. Speaker.
Honourable David Parker.
Thank you, Mr. Speaker. Can I thank the attorney for his comments? I agree with him that the state of the Evidence Act in New Zealand is very good, in large part because of the expertise that was brought to bear by the ministry. Very good advisors then at the Justice Ministry. It would have been Warren Young back then, would it, Mr. Attorney, that would have been in the Department of Justice, and probably also through his efforts at the Law Commission at one stage, and an expert committee with the experience and expertise of Russell Fairbrother and Chris Finlayson, as well as Robert Fisher, meant that there was a high-quality piece of legislation passed in this House in 2006 in the form of the Evidence Act. And it's a very, very long bill, the Evidence Act, very complex. And the fact that here we go 7 years later, putting it through review, and we've got this number of amendments, actually, I think shows what a good job that the Parliament did in 2006 when it passed the 2006 Evidence Act. I will traverse the main points of the bill, but before doing so, the Minister ended by talking about some of the other issues that are being, or the other initiatives that are being pursued by the government, including iPhone evidence taken by constables at the scene of a domestic violence incident, enabling the evidence of the complainant to be taken once, to be taken quickly while their memory is still fresh. They don't have to arrange childcare for their children while they go down to the police station to make a statement. And I think it is truly in the interests of justice that we facilitate that sort of gathering of evidence and the use of that evidence at trial should charges be laid. I do have a personal concern that we need to be very careful about one of the proposals that's currently about, which is to say that in some of these sexual crimes we ought not to have trial by jury. I'm yet to be convinced that that's right. You know, trial by jury has been an essential component of the criminal justice system for many centuries, and I am not convinced we should drop it. You've got to think about what would happen 20 or 30 years hence if you have a deterioration in your democracy and perhaps a poor government where, and I'm not suggesting either any of the parties currently here would necessarily act like this, but you've got to guard against the potential that you have a poor government in the future that brings inappropriate prosecutions, might be bringing prosecutions for reasons not, there might have been a breakdown of the independence of the role of the police. You could have politically motivated prosecutions, as you see in some other jurisdictions overseas, and one of the fundamental protections you have against that in society is trial by jury, and at that time you really can, in my opinion, rely upon juries to do the just thing, and so I, for one, will be very reluctant to give up the right for a defendant or an accused to elect trial by jury in serious cases. Sir, in respect of the main aspects of this legislation, I agree that the three main improvements in the bill are improved rules around child witnesses. Already, as the Attorney Chris Finlayson has said, most child witnesses give evidence either at a distance or behind a screen, and it is, as he has said, a tough thing to do, particularly when the person against whom evidence is being given is often a family member. So it's very, very hard for the child concerned, and we need to protect those children from that experience being any more difficult than it has to be. Obviously, there are certain circumstances where the accused, through their lawyer, still has to be able to ask questions of the child witness, and not all of the rigours of trial can be avoided, but it can be made less tough through some of the protections, such as the change which is made in this bill, which is, rather than it being a matter of discretion on the day, create a presumption that the child witness can give evidence in one of those other methods which are slightly less stressful. That presumption can be overturned in some situations by a court, but that's for the court to determine. The presumption is now made by this law. In respect of victims and sexual crimes being tested as to their prior sexual history, I agree it's appropriate that that be done pre-trial. that advance notice be given so that people can get used to the idea, and also so that really a question can be asked by the trial judge, is this really necessary? And sometimes it won't be necessary, and through this process I think it'll probably occur slightly less often. Sometimes it will be necessary and is relevant and not determinative, but these processes will do that in a better way too. In respect of video evidence, what the attorney was hinting at was that there are some horrible people in society who will actually use the videos of evidence against the person who has given the video. So they will put them on the web, or they'll share it amongst other people, or they'll just use it as an angle to further abuse, really, the person who's giving evidence. And we shouldn't condone that. And given that there are some people with that propensity, and given that there are copying techniques that didn't used to exist, we've got to keep the law up to date, and we've got to make sure that that doesn't happen. So I think it's absolutely appropriate that we introduce through this legislation controls on the access to video evidence of witnesses in sexual crimes, for example. I mentioned one other thing that's fixed up by this bill. The rule against hearsay has an exception in respect of business records. Normally, the evidence that's tendered at a trial has to be evidence of someone who is in the position to give the best first-hand evidence of what's being deposed to in that evidence. There is an exception in respect of business records because you can normally rely upon prima facie the evidence of a bank statement being accurate as to what it presents. So if there's a deposit made on the 1st of July for $10,000 and it shows D. Parker as the source of it on the coding on the bank statement, you can generally rely on the bank getting that right, and there's no need to call evidence to prove that there was in fact a deposit by D. Parker on the 10th of on that date for $10,000. The business record can be accepted on its face. Can have obviously been cross-examined, but if there is a doubt as to whether it's some fraudulence around that transaction or the like, but generally prima facie that can be accepted on its face as an exception to the rule against hearsay. So that exception to the rule against hearsay is found in the Evidence Act, but it was drafted in a way which was so broad as to encompass a witness statement given to a police officer would have fallen within the definition of a business record. That's the record that the police kept of the interview of the witness. And it wasn't intended that that be the case. In that case, you actually fairly want to have the witness who gave the statement to the police turn up to give evidence themselves and tell the court, the jury or the judge what it is that is, what their evidence is, rather than just tendering a statement from the police of their record of the interview, because the viva voce evidence of the witness is better evidence than the statement by the police officer, which might be edited or might not be a perfect recollection, or there could have been some misinterpretation of what was said, and it's better to get the evidence of the person themselves. So this evidence amendment bill makes it clear that the business record exception to the rule against hearsay does not include a police record that contains any statement or interview by or with an eyewitness or a complainant or any other person who purports to have knowledge or information about the circumstance of the alleged offending. So that is tidied up by this provision. Can I, sir, thank the Select Committee for their work, thank the submitters to the Select Committee, including the Law Society, who in this area do a lot of really good work in the public interest as volunteers, giving of their own time to make sure that the law that we have is better than it would otherwise be. So, sir, the Labour Party will be supporting this bill at its third reading, as we have in earlier stages of the bill. Thank you.